Mr. Chairman, we are live.
Thank you, Mr. Secretary. Good morning. Welcome to today's administrative meeting for May 6, 2020. We'll get started this morning by approval of the minutes for last week's meeting on April 29th. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
And Commissioner Herman.
Aye.
I vote aye. The minutes are approved. Mr. Secretary, what do we have on the consent agenda?
Mr. Chairman, there are 7 items on today's consent agenda. Item 1 is a notice of participation in financing arrangement from CenturyLink Communications LLC. Item 2 consists of revised tariff pages from EXO Communication Services LLC. Items 3 and 4 are the applications of DeMoyen Linton LLC DBA Inertia Resources for licenses to supply natural gas or natural gas supply services and electricity or electric generation services in Maryland. Item number 5 is the application of Independent Energy Consultants, Inc. for a license to supply electricity or electric generation services in the state of Maryland. And items numbers 6 and 7 are the applications of Brookfield Smoky Mountain Hydropower LP for certification as a renewable energy facility for the Maryland Renewable Energy Portfolio Standard Program for the Chilowee and Santalia hydroelectric power plants.
Thank you. Do commissioners have questions? Commissioner O'Donnell.
Thank you, Mr. Chairman. I'll have a question on item number 2, which should be brief, and then I have maybe a couple more on items number 6 and 7 together. On item number 2, whoever on staff has that, if you're prepared, and I apologize for not getting this, making this question known earlier, but my question on item number 2 is this. If you go to page 1 of the agenda check sheet, the buck sheet nominally, but it's check sheet, and you look under the second paragraph, description of transaction, it talks about the company not taking new customers into the special access services tariff. And I'm going to hang on, Mr. Chairman, while my clock. I apologize. That chime can be rather annoying. But
It looks like it's slow.
It is. So under the description of transaction, no new customers under this tariff, but then there's a sentence that says moves, additions, or changes will no longer be permitted for existing customers. And that almost reads to me like existing customers are stuck in this tariff provision forever. So could someone tell me what that sentence really means? Because I know it can't mean.
Good morning, Commissioner. That was my item. After Howard on behalf of staff. So there are currently no customers in Maryland subscribed to their service. And I believe that the company wants to have unified language across all of its service territories. So that's why it's grandfathering the language in this item.
Okay, what would that mean in another service territory? I know there's no customers here. Thank you for informing me of that, but moves, additions, or changes, maybe it'll come up in the future and I'll be at least illuminated a little bit, will no longer be permitted for existing customers. You know what that means?
I am not quite sure,
All right.
but staff can look into it.
Fair enough. Fair enough. We'll follow up later. Thank you. I appreciate that.
Thank you.
Thank you, Mr. Chairman. On items 6 and 7, if I can just proceed, if that's okay. These items began operation in, I see in 1957. I read the first one, number 6, 63 years ago. I thought, wow, that's older than me. That's a long time ago. Then I got to number 7, and I found out that that one began operation in 1928, 92 years ago. thought, wow, these RECs aren't providing any incremental increase in renewable energy infrastructure, which I believe the whole program was created to incentivize the creation of new renewable energy infrastructure. 1928 was that may be older than the Conowingo Dam. I don't know. So if anyone has can answer just a couple brief questions on these two items, I'd appreciate it.
Thank you. I believe we have and Catherine.
Good morning, Chairman and Commissioners. Paige Shaw on behalf of staff. These two are my items.
Thank you, Ms. Shaw. Where are these? Some of these are obvious, but where are these two projects located?
Item 6 is located in Tennessee, and item 7 is in North Carolina.
What's the approximate value of the RECs for these two projects that will go to North Carolina and Tennessee, respectively? Do we know?
Yeah, each facility is about $200,000 per year in RECs.
$200,000 a year in RECs for facilities that were built in 1928 and 1957. Okay. But the legislature, I mean, Tennessee's not in PJM. A small part of North Carolina is. I don't know if this facility's in that portion of PJM, but could the legislature change the public utility article in any way, to your knowledge, to change this? I mean, I've had a long-standing concern about monies going out of Maryland to faraway states like Tennessee and North Carolina and Illinois and Kentucky and Indiana and Lord knows where else. That money's just going out of our economy in the state. And these current conditions certainly make me think about how important state economic resources are going to be going forward for some time. Could the legislature change the public utility article to preclude this, much like we do with the carve-outs for solar? We say a certain amount of solar has to be in state, or is as some legal minds have alluded to me, there's a problem with the interstate commerce clause in the Fourth Amendment. Do you know the answer to that question? If it's too much and you don't know, it's okay. You can follow up with me later.
Mr. Commissioner, this is Kevin Mosier of staff. The legislature allows RECs to qualify for PJM if they're outside, if they're in an adjacent RTO, but they're delivering the RECs into PJM, which these facilities are. However, you are correct. The legislature was changed, or the legislation was changed in, I think, 2012. Prior to that, RECs from a facility in any adjacent state would qualify, even if they weren't delivered to PJM, but that no longer qualifies. In fact, there were a number of hydro facilities in New York that used to get RECs that no longer do for that reason.
I appreciate that. I really, what I'm asking though is, could the legislature require a certain percentage of these types of RECs, non-solar RECs, to come from within the state of Maryland, much like we do the solar RECs?
I don't see any reason why not. We have very similar language. Well, actually, in fact, it's identical language that's connected to the distribution grid. That's for solar, geothermal, waste to energy, and I believe poultry litter. So the legislature has restricted certain fuels to be connected to the distribution grid in Maryland.
Well, I'm the only one that talks about this for the most part, for the better part of 4 years, AM in and AM out. And I just think it's a shame that this money is going out of state, in this instance, to facilities built in 1928 and 1957 that provide no incremental benefit to the environment, in my opinion, or to anything else. It's just sucking money out of our state's economy. And these are poster childs 1 and 2 for why we need some adjustment to keep that money in the state. So thank you for answering my questions. I appreciate that. Thank you, Mr. Chairman. I'm done on these items.
Thank you, Commissioner O'Donnell. Seeing no additional questions, I will make proposed motions for each of these items. With respect to number 1, that we note the company's participation in new financing. With respect to item 2, we accept the revised tariff pages for filing with an effective date of May 8th of 2020. With respects to items 3, 4, and 5 collectively, that we grant a company a license to operate as a natural gas supplier in Maryland with respect to items 3, and as an electricity supplier in Maryland with respects to items 4 and 5 for the customer classes and service territories applied for and recommended by staff, and direct the companies to file notice with the commission within 30 days of any changes to the information in its respective applications. With respects to item number 6 and 7, that we approve the applications and issue a renewable energy facility certification number, that we direct the company to establish a REC account with PJM GATS within 30 days of certification, and direct the company to file notice with the commission within 30 days of any changes to the information in the applications. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
And Commissioner Herman.
Aye.
I vote aye. The motions are approved. Mr. Secretary.
Mr. Chairman, item number 8 on the administrative agenda is Potomac Edison's request for a waiver of CPCN requirements for transmission line repairs. In this item, we have Christopher Lowe and Peter Wilson from staff, and Jeffrey Trout and Ryan Grady from the company.
Thank you. Good morning. As the parties present, please turn on your mics, and if you're not presenting, please turn off your mics. We'll begin with Commission technical staff.
Good morning, Mr. Chairman, Commissioners. Christopher Lowe on behalf of staff. This item concerns a request from the Potomac Edison Company for the Certificate of Public Convenience and Necessity waiver pursuant to Public Utilities Article Section 7-07B4I. PUA Section 7-07 requires an electric company to obtain a CPCN prior to commencing construction of an overhead transmission line that is designed to carry a voltage in excess of 69 kV. However, exceptions are.
Chairman, Mr. Lowe, excuse me. Mr. Chairman, I can barely hear Mr. Lowe. I don't know if it's just a problem on my end or if it's a generic problem.
Can everyone hear me okay?
That sounds a lot better. Does that sound better to you?
Yes, it does. Thank you.
Okay, I'll just continue there. All right. PUA Section 7-207B4I further states that the Commission shall waive the CPCN requirement should it find that construction does not require the company to obtain new property or rights of way through eminent domain, or require larger or higher structures to accommodate increased voltage or larger conductors. Potomac Edison's mandatory waiver request is for the replacement of approximately 30 miles of static wire and repairs to ancillary equipment associated with the existing Garrett Ridgely 138 kV line that runs approximately 32 miles in western Maryland. This 138 kV line has experienced reliability problems over the past 10 years, which has resulted in a total of 24 line equipment cost outages between 2012 and January 2020. 83% of these outages were attributed to static wire and down-ground failures, which is targeted for replacement during this repair work. This project will address the reliability concerns associated with the aging equipment along the existing Garrett Ridgely 138 kV line. In its filing, Potomac Edison states that the repairs will be performed on property already subject to easements held by the company, and there will be no increase in the voltage or the size of any conductor. Therefore, the project meets the requirements for a mandatory waiver. Based on staff's review of the filing and discovery responses from Potomac Edison, staff concludes that the completion of this project is needed to maintain the reliability of the system, and that statutory requirements under PUA Section 7-207B4I for obtaining an CPCN waiver have been met. Staff recommends that the Commission grant a mandatory waiver of the CPCN requirements pursuant to PUA Section 7-207B4I applicable for the work described in this filing.
Thank you, Mr. Lowe. Counsel for the utility.
Morning, Mr. Chairman, Commissioners. Jeffrey Trout for Potomac Edison. We agree with staff's recommendation, and we're here to answer any questions you have.
Thank Thank you, Mr. Trapp. Do any commissioners have questions? Hearing none, I will propose a motion that we.
Mr. Chairman?
Yes, Commissioner Richard.
Yeah, can I just ask a couple questions of Mr. Lowe? Is there a reason, I mean, you talk about it's the staff interpretation, but it almost seems that this is outside applicability of the public utility article here. Why are you, and you say that there could be additional interpretations. Why wouldn't we just note the filing here? Because while you say that there could be significant replacement, that doesn't seem to be one of the triggers for requiring a waiver or even consider this as construction. So can you just help me understand that, why we wouldn't just, note the filing and not put the company, well, I guess they're not being put through anything, but just, wouldn't it be more clear if we just note the filing and draw some lines here so that there is an understanding what requires a waiver and what does not? Would that be good to provide that kind of guidance to utilities or anyone constructing transmission?
Well, after reviewing this case, staff determined that this project does involve some sort of construction, because the replacement of the static wire definitely involves a physical change along this existing transmission line, requiring installation and the removal of the static wire. So it does meet the requirement, the statutory definition for a construction project. That's why I'm sorry that there's a background noise. So we determined that it is a construction because it involved the installation and the removal of the wire, but it could be a different interpretation if the commission agreed.
Oh, okay. The way I read your the buck sheet, it sounded like you were just doing this out of caution.
Yes.
And that I just wonder if that's a good idea, if we always just caution on the side of overzealous regulation and rather than just providing guidance. But under that circumstance, if the staff believes that it does meet the definition, then that's fine. Thank you.
Mr. Chairman, this is Jeff Trout. I had the same question when I was preparing this filing that Commissioner Richard just raised. This is an opportunity, as the commissioner pointed out, for the commission to clarify its interpretation of the word change in the statute. The commission's interpretation would be entitled to appropriate administrative deference for the expert agency interpreting the statute. In this instance, while we are doing a fairly extensive set of repairs, we are not making any changes to the conductor. We are not making any changes to the pole. We are not acquiring any more real estate rights for any purpose. So if you chose to interpret the word change in the statute, apply to those three factors, the real estate, the poles, and the conductors, that would be a line that you could draw. You could note this filing, and in the future, utilities would know that this kind of repair would not require a CPCN waiver filing. I readily acknowledge, however, that it is for the commission to interpret that language, and that is why I made the filing, and that is why in a footnote to it I raised the issue which staff very graciously chose to address in their filing as well. So, the ball really is in your court, commissioners, and I, for one, would welcome the thought that Commissioner Richard has advanced.
Thank you, Mr. Trout. It's obviously an issue for us to consider in future cases now that the item has been flagged. So the commission and technical staff will be on the lookout for this issue going forward. Thank you. Any additional questions from commissioners? With that, I propose that we grant the company's request for a waiver of the CPCN requirements under the Public Utilities Article Section 7-207B4I. Permit the company to repair the ancillary equipment associated with the existing Garrett to Ridgely 138 kilovolt transmission line. The vote begins with Commissioner Richard.
Yeah, in this case, I mean, I would have preferred the note to filing, so I will signal that, but I'm not going to, vote against this, so I vote aye.
Commissioner O'Donnell?
Aye.
Commissioner Linton?
Aye.
Commissioner Herman?
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 9, a request from Southern Maryland Electric Cooperative for the issuance of debt. For staff on this item, we have Drew McAuliffe and Lloyd Spivak, and for SMECO, we have Mark McDougall, Sonia Cox, and Beth Kennedy.
Thank you. Good morning, technical staff.
Good morning, Mr. Chairman. Drew McAuliffe on behalf of staff. On April 15th, 2020, Southern Maryland Electric Cooperative notified the Commission that it applied for the Small Business Administration's Paycheck Protection Program, also known as PPP. SMECO applied for the loan in the PPP on April 6, 2020, and accepted the loan of $8.5 million on April 20th, 2020. The company indicates that the proceeds from the loan will be used to cover payroll costs. Under Public Utility Article 6101A2 and 6102B, a public service company that operates in Maryland may not, without prior Commission authorization, issue debt that is payable wholly or partly more than 12 months after the assumption, guarantee, or issuance of any of those items. SMECO requests that the Commission treat SMECO's PPP loan as a short-term loan not payable in whole or in part in more than 12 months. And if the Commission determines that the PPP loan is short-term debt, SMECO asks that COMAR 200704 requirements be waived. However, because the terms of the loan are for 2 years, staff recommends that the loan be treated as long-term debt and subject to the requirements in COMAR 200704. SMECO has complied with all COMAR requirements but 2 in COMAR 20070402A12, which requires an affidavit from 3 board of directors, and 20070402B, which requires SMECO to advertise the loan application in local newspapers. Also, because SMECO has already accepted the loan, staff requests the Commission grant the application nunc-pro-tunc because of the current pandemic. Pursuant to Commission's March 20th, 2020 notice of waiver, the affidavits required under the Code of Maryland Regulations 2007-0402 have not been notarized. Staff recommends that the Commission grant the application nunc-pro-tunc and issue a final order in compliance with COMAR 2007-0402C, authorizing SMECO to incur up to $10 million of indebtedness, and requires SMECO to provide the required documentation as described in COMAR 2007-0402A12 and 2007-0402B. Thank you.
Thank you, Mr. McAuliffe. Counsel for the utility.
Good morning, Mr. Chairman, Commissioners. I'm Mark McDougall on behalf of SMECO. As staff mentioned, under the PPP, because payroll costs are an intended use of the funds, the PPP loan will be forgiven. And if for some reason the loan is not forgiven, SMECO has committed to repay this loan in 12 months or less. Under either of these 2 cases, whether the loan is forgiven or repaid within 12 months, no part of the loan will be outstanding after 12 months. Now, the Maryland Annotated Code and COMAR both require a utility to get Commission approval before assuming debt that is to be repaid in whole or in part more than 12 months from the date of issuance. Because under either of the 2 scenarios I've just described, SMECO will have no part of the loan outstanding after 12 months. SMECO has asked the Commission to view the PPP loan as a short-term loan and not subject to the Maryland Annotated Code or COMAR provisions pertaining to long-term debt. Now, as Mr. McAuliffe mentioned, the fact remains that SMECO was required to sign a note with a term of 2 years. All applicants for the PPP loan were required to adhere to that 2-year term, irrespective of the fact that the loan will either be forgiven or repaid within 12 months by SMECO. Staff has taken the position that this 2-year term requires SMECO to comply with the COMAR provisions pertaining to long-term debt. The two COMAR provisions that staff has highlighted that SMECO had not complied with are the one pertaining to affidavits of 3 directors stating how the funds would be used, and an advertisement requirement that SMECO's request for commission approval of a loan would have to be advertised in local newspapers 2 weeks after its application with the commission. Commissioners, first, SMECO did not believe that these provisions were necessary because SMECO viewed the PPP loan more as a grant because of the forgiveness provision of the PPP, and that no loan would exist after 12 months. However, SMECO believes that good cause exists to waive these provisions if the commission believes that they apply. As to the director's affidavits, because of the pandemic, SMECO's board had a virtual meeting on April 21st with no director participating in person at SMECO's facilities. This made them unavailable to sign an affidavit, much less have that signature notarized by somebody watching the signature. So instead, SMECO's president and chief executive officer, Sonia Cox, executed an affidavit that we believe would be an appropriate substitute for the director's affidavit. As to the public notice, the process for applying for a PPP loan because of the pandemic was greatly expedited. As Mr. McAuliffe mentioned, SMECO submitted an application for the PPP on April 6th, which was a Monday. And then by the 16th, SMECO notified by the lending bank that it needed the note to be executed. So SMECO signed the note and returned it to the bank. The timing between when we submitted the application, the time we had to sign the note was only 10 days. So there was not even a 2-week period for which notification could take place. This is why, in the alternative, SMECO asked the commission to waive the COMAR provision for good cause shown. Commissioners, SMECO renews its request to treat SMECO's PPP loan as a short-term loan not payable in whole or in part in more than 12 months, or in the alternative, for good cause, waive the COMAR provisions pertaining to long-term loans non-pro-tum. Thank you very much.
Thank you, Mr. McDougall. I believe the commissioners have some questions. We'll start with Commissioner Linton.
Mr. Chairman, and good morning, everyone. I had a couple of questions for staff and several questions for the company. First, since we have an additional filing from the company that came in after the staff's comments, I was wondering if the staff had any response to the company's filing from April 21st. It came in after your bucksheet filing, so.
Well, first of all, just to respond to Mr. McDougall's comments, we just felt that the COMAR requirements should still be followed. I mean, considering they've already accepted the loan, we don't have a problem with them issuing, an advertisement in local newspapers now or going forward basis. Also, in regards to the affidavits from the board of directors, the commission did pass the order on March 20th, which I noted in my comments, that they don't have to be notarized at this time. So they did provide one affidavit. We were simply just asking for 2 more to show, to follow COMAR, because as I stated, we believe because the loan is for 2 years that SMECO should be following the COMAR requirements. I think they're pretty followed pretty simply, frankly.
Mr. Chairman, might I respond to that?
You may.
SMECO does not see any useful reason to place place a advertisement in local newspapers as to the process that will have occurred at the Public Service Commission. Notice provisions are to alert the public for things that will be happening, not so much to alert the public for things that took place for which they were unable to comment or participate or anything else for that matter. So again, for good cause in this particular situation, SMECO asked the commission to waive that provision because it serves no useful purpose.
Mr. Chairman, if I might speak just quickly on that point.
Mr. Spivak, yes.
Yes, I mean, the fact is that the company has already received the funds. But the question we have is whether their membership actually knows what has transpired. And I grant that in this instance, they can't object to what has already happened and reverse what has already happened, but it can at least provide them with information about what their cooperative has done. And that we would want them to have that information.
Mr. Chairman, if I may, SMECO has many different ways of notifying its membership on activities that occur within the cooperative. This sort of notice that is contemplated by COMAR is not one of those methods that SMECO would normally use, nor is it the purpose of COMAR. So in this particular instance, we still don't think that COMAR would apply, that provision of COMAR would apply, and we ask that it be waived.
Okay, we're debating a very relatively minor point here. Let me return back to Commissioner Linton on his line of questioning.
Thank you, Mr. Chairman. Still directed to the commission staff. I just wanted to be clear that the staff's proposed recommendation, was that intended to, for lack of a better word, satisfy the company's request that they outlined on page 2, bottom of page 2, on their April 14th filing, where they specifically directed that they're requested, well, in case you don't have it in front of you, that the commission determined there is good and sufficient reason to waive the COMAR requirements, I'm inserting COMAR, and grant SMECO authority to incur up to $10 million of indebtedness under and pursuant to the terms of the PPP.
Yeah, so in answer to your question, yeah, the recommendation was, staff's recommendation was simply to fulfill the requirements of COMAR. We felt that because, again, the terms of the loan for 2 years, that the COMAR provision should not be waived. And SMECO has met all the requirements except those 2 that I outlined. So yes, I guess our recommendation was in response to that request from SMECO.
I think I would also add that we don't view the COMAR requirements for this particular type of application to be particularly burdensome. And even in the unusual conditions we have now, we still don't consider them to be that much of a burden. And we really do not want to put the commission in a position of waiving COMAR requirements lightly. It's an action that should be fairly extraordinary and should be done with a great deal of consideration. So, and we didn't see a need really to do it in this instance.
Mr. Chairman, may I respond to that, please?
You may, Mr. McDougall.
Okay.
Again, I think we're debating a very minor point here. I think there might be some bigger issues, but Mr. McDougall, you may respond.
Just very briefly, the cooperative does not believe that these requirements are burdensome. They are not burdensome. We just don't think they're appropriate at this point in time. And that the situation that is in front of us today is extraordinary. It is not one of those situations that the commission would be waiving its regulations without extraordinary reason. Thank you.
Commissioner Linton, if I could interrupt your line of questioning for a moment. Mr. McDougall, if possible, would you be able to provide those 2 affidavits and publish the notice by close of business today?
I don't I would have to see whether the directors would, whether I got two directors who are available. And I guess I would have to see if I could have a notary accompany me or someone else to their homes to witness the
As Mr. McCullough just said, there's no notary required, and this could all be done electronically, I imagine. But
I can get the affidavits executed today, most likely. I could not get the advertisement in the newspapers published today.
okay, well, we'll hear from the other commissioners on this point. Mr. Linton, thank you for yielding. Back to you.
Sure. Thank you, Mr. Chairman. Back again to staff. If your recommendation is intended to satisfy the company's request for approval to apply for this for the PPP loan, and you've suggested that this be approved by the commission nunc pro tunc. This, in effect, means that the commission would be authorizing the company to apply for the PPP loan and under the terms of the loan, which is the conditions of the financing, however they may be laid out. So I'm curious as to whether or not the staff is familiar with the terms of the PPP, how it works, and if they consider that as part of the recommendation.
Yes, so SMECO has already received the funds and has already been approved for the loan. That's why we recommended the nunc pro tunc. Yes, we are aware of the terms of all PPP loans, excuse me, are for 2 years with a 1% interest rate. So because it is for 2 years, staff felt that the COMAR should be required. I know obviously for debt filings, we usually, the commission provides authorizations to get the funds. Now I know that's different in this case. Now because of the time sensitivity of the loan, SMECO only had 5 days to sign the agreement, which Google said they received, I believe, on April 16th. So because of that, we obviously weren't going to limit SMECO's ability to accept the loan because they did it prior to commission approval because of the time sensitivity. But again, because of the terms, we felt that COMAR requirements should still be followed. That answers your question.
Yeah, so thank you for that, Mr. Paul. If you've actually gone to one of the areas where my concerns regarding this particular request have peaked a bit. Typically, the commission doesn't approve the terms of financing. The companies, we just approve the authorization to secure financing. In this particular case, it's a particular type of loan financing with certain eligibility requirements on the front end and certain payoff requirements on the back end. So if we authorize this request nunc pro tunc, is it the staff's conclusion that the commission is authorizing not just the application, but the payoff terms as well?
I'm not sure that the commission would be authorizing the terms. I think it's just the application, in my opinion. The term staff is bringing up the term simply to note that this is, according to COMAR, a long-term debt application. I don't know that the commission is necessarily accepting the terms of 2 years and 1% interest rate. We simply bring up the terms to note that we consider this long-term debt.
So you don't think that the commission is making any comment regarding the company's eligibility for one of the PPP loans?
I don't believe so. No, through our discussions about this filing, it's really through the SBA and the banks who determine the eligibility for this PPP loan.
Is the staff aware of any other mechanism the company may have been able to pursue to resolve any challenges they may have had regarding meeting their payroll?
I would say that the company would be better answered would be better able to answer that question. I'm sure they could have limited capital expenditures and things of that nature, but I'll let Mr. McDougall that question. Good.
Okay. Thank you, and thank you for that. Then I'll switch over to the company. Mr. McDougall, if you could just tell us, because your request, the staff is recommending that this request be approved nunc pro tunc, and in your April 14th filing, you specifically requested that the commission determine there is good and sufficient reason to waive the requirements so that SMECO can incur the indebtedness pursuant to the terms of the PPP. So if you could just tell us what are the terms of the PPP? I mean, I understand the financing and repayment terms. Because this is non-protunct, that also would include the application component as well. So is there anything we need to be concerned about? Are there any application related issues that we should be concerned about?
Chairman, Commissioner Lenton, I see I don't believe there are any complications that you should be aware of. I know of no other complications. I'm not aware of any, so if there were, I'd let you know. I don't believe that there are any.
Okay. When the company first submitted this application to the issuer of a loan, obviously all the loans are set for the same repayment terms. Did the company talk to the insurer about repaying over a shorter period of time? I understand there's no early repayment penalty or anything. So was that part of the discussion or part of the application process?
I don't believe there was any discussion between SMECO and the lender. If you give me just a moment, I will inquire with our Chief Financial Officer, Beth Kennedy. Kennedy.
Sure.
She says there was no specific discussions between the cooperative and the lender on a repayment term shorter than 2 months. Excuse me, 2 years.
So this would just be the company proceeding to pay it early.
That is correct. And we not only have committed verbally to that, our Chief Executive Officer has signed an affidavit to that in that regard.
So I guess, just going from the conversations and the discussions in general, across the general media, there's generally a concern that these types of loans were for companies that had a very significant need for them. Is there something that the commission needs to know about? Is there a challenge that SMECO is facing now regarding its general operating on a day-to-day basis?
As of today, Commissioner Linton, SMECO is not at risk for meeting its payroll obligations. The key here, though, is uncertainty. And SMECO faces that economic uncertainty in the form of lost load, especially with regard to small and large commercial accounts. We don't know how long this pandemic is going to last in the effect on the economy and the effect on local businesses. Right now, all the utilities in the state are unable to charge late charges or terminate customers for non-payment, residential customers for non-payment. We don't know how long that will last. The pandemic has just raised a big question mark in all of our minds. And as we move forward, we don't know how that would impact our financial ability to operate certain parts of our business, including meeting payroll. So when this opportunity came about, it seemed prudent for the company to seek loans under the PPP in the event that we did face that economic uncertainty came to bear.
Okay. So just a couple more, little more generic questions then. In your earlier, in your first comments on the 14th, you discussed that there were a number of cooperatives that were considering applying for the loan. Just through your general interactions with other cooperatives, do you know of others that have applied to request and receive these funds?
I can't, without making specific inquiries across the cooperative nation, whether or not particular cooperatives have applied for the loans. I know that, I just know from email traffic I have seen come across my desk that there were a number of cooperatives. I say a number, I would suspect a lot of cooperatives have applied, but I don't know precisely who they are.
Okay.
Commissioner Linton, if I could interject, Mr. Spivak and I talked with a gentleman at NRECA, the National Association for Cooperatives. He did say he didn't have specific numbers for us. We talked to him a few weeks ago, but he did note that quite a few cooperatives had applied for this PPP loan. Again, he didn't have specific numbers, but he did seem to insinuate quite a few had applied for this program.
Okay, thank you, Mr. McCall. Just one final question then for the company, and thanks everybody for indulging me. Mr. McDougall, you requested an expedited treatment for this particular application. However, the company's already received not only the approval, but my understanding from the April 21st filing is that you've already received access to the funds. So is there still a need for an expedited treatment, or does the commission have the opportunity to review further, or is this something that the company needs a response to as soon as possible?
On April 14th, when the company first filed its letter with the commission, we didn't have really any idea on the rapidity with which this process would take place. We didn't know when we would be required to sign a note, how fast we had to turn it around, other than the statutory 10-day period that we had seen in the PPP. We didn't know when it was going to come or when the funds were going to become available. So that was why we had asked for expedited consideration. I think at this point, since MECO has now already applied for and received the PPP funds, I'm not sure that expedited consideration is still necessary. So if the commission wanted to take some time to consider this and issue an order as it deemed appropriate, then we would accept that. We're just trying to, because of the rapidity of the process, we wanted to be able to get this before the commission as quickly as possible.
I understand. And thank you very much. And we appreciate the rapidity from the company's perspective. Thank you very much, Mr. Chairman. I have no further questions.
Thank you. Commissioner Herman.
Thank you, Mr. Chairman. Good morning, everybody. I'd like to ask some questions of Mr. Spivak. Mr. Spivak, since the commission is not permitted to waive a statute, and since the statute requires that any loan that's greater than 12 months be approved by the commission, would it be your opinion that the governor's executive orders allowing for extended time periods would apply, and that therefore even if the commission were to consider this a 2-year loan in terms of the loan itself, that we have some latitude with respect to the statute because of the governor's orders?
I think you could read the governor's orders to give you that latitude. I don't know that there is a necessity to do so. Again, it is the problem I think we have here is that the assertion that this is only short-term debt because they're going to pay it off in 12 months is that is simply an assertion that the company is making. Granted, it's a commitment that the company is making because they have provided an affidavit to that effect. But the formal terms of the loan still remain at 2 years, and that was the basis of our judgment that this should be regarded as an ordinary debt issuance. And we did not feel comfortable making the judgment on our part that given in light of the company's commitment, the loan should be viewed as a short-term loan. So we didn't feel comfortable with making that legal determination. The commission is within its rights probably to do that if it chooses, but it's a stretch because of the terms of the loan. These are extraordinary circumstances. We don't deny that, and that's why we had asked why we're not making any kind of a fuss or an issue over the fact that really this is after the fact approval where the statute requires prior approval. And the commission has, in appropriate circumstances, done other things non-pro-tunc, so we felt comfortable with that recommendation.
Okay. But if the commission were to, as staff does, look on this as a not short-term debt because of the actual terms of the loan, despite the assertions that they're going to pay off, we also have the executive orders on which we could rely to address the timing issue. Is that not correct?
I believe that is correct, Commissioner.
Okay. And the same would apply for the COMAR requirements as well, right?
Yes, and the fact that the COMAR requirements are not a statute, that they are the commission's regulations.
Right. And there are I believe it's correct that we don't need to notarize in today's environment. Notaries are not required under executive orders.
That's correct, and that's also the commission's prior order.
Right. Okay. So if the commission I want to be clear that what staff believes that the commission would be approving or accepting in this particular case. The commission would be, all we're doing here is saying that the provisions of the loan, if the commission were to approve it, that the two-year provisions, non-pro-tunc or under the executive orders, it's just simply the term of the loan that the cooperative would be permitted to enter into this loan with a 2-year payback, and the commission would potentially approve that. We're approving, that's what we're approving, right? We're not approving, or are, let me rephrase that. Are we approving SMECO's qualifications for a PPP?
No, Commissioner, what you are doing is you are authorizing SMECO to issue or take on debt. That's what the commission is required to do by statute. The specific terms of the debt, you are not approving or authorizing. But the question that has been posed to the commission is the question of whether or not this is what you are authorizing is long-term debt. And whether you are required to authorize the debt issuance. Because if it is long-term debt, you are required to give prior authorization debt issuance. If it is not, then the cooperative is entitled to do it without any action on the commission's part.
Okay, thank you very much. I think that's a very important point, that our all we're talking about is this short-term debt or is it long-term debt? And if we decide that it's long-term debt, will we waive some of the notice requirements and some of the affidavits? That is all we're doing here. And to me, that's a very important point. And to the extent we approve this today, I want to make it crystal clear by our motion, if we were to approve it, that that's all we're doing. Thank you, Mr. Chairman.
Thank you, Commissioner Herman. Commissioner O'Donnell.
Thank you, Mr. And, I think I'll start with staff. Staff, explain to me again what the purpose of PPP is.
Yes, so, this is Drew McAuliffe. The purpose of the PPP was to is for companies to keep their payroll, to be able to afford their payroll expenses and keep employees on the payroll and hired without having to lay off any employees.
And that was the first tranche of that. The first bill passed by the Congress was about $350 billion. Is that right?
Yes. I believe the first tranche was 349 billion, and the second was, I believe, around 320 billion.
This particular loan application by SMECO, it's coming out of that first tranche, right?
Correct.
That's the one that ran out of money?
Yes.
And that's the one that a lot of press was generated, media was generated for institutions that really didn't need the money, but took the opportunity to get a low interest, no interest grant or loan, whatever you want to call it, forgivable loan. Is that right?
Yes. You know, I think Paycheck was a big one that, you know, returned money. I believe Harvard returned money.
Harvard, a lot of other institutions that had multi-billion-dollar endowments and whatever, large and small, Ruth's Chris, whatever they were. There was a lot of kind of public shaming because the little businesses, the true small businesses, the mom and pops, didn't have the ability to access these funds. They don't have legal departments, and they don't have regulatory departments, and they don't have big bureaucracies. They are literally mom and pops with maybe 8 to 10 employees. Is that right? And that's what happened in America?
Correct, yeah.
Because they're not worried about margins. They're worried about being able to stay in business, right? That's the whole thing was geared towards keeping these people in business. So let me ask you this. Did the staff evaluate SMECO from a financial health perspective? I mean, are they an extremis, like a small mom and pop business that's getting on a banana peel, getting ready to go out the door and collapse? Because if they are, and if staff evaluated that, we've got a bigger problem, not just with SMECO, but with all of our utilities, maybe. So speak to me about the examination that staff did on the financial health of SMECO because of COVID-19.
Yeah, so we didn't go into great depths on their financial health. Again, you know, the approval of the PPP loan is through the bank and the SBA. So the fact that SMECO was approved, we felt that they provided sufficient information. Again, it's also hard at the time they applied. It's hard to quantify the impact of the COVID-19 pandemic so far, considering we just kind of shut down in March in Maryland. So the effect that would have on their ability to you know, keep employees on the payroll, we weren't able to, you know, measure that as of yet. You know, we did ask data requests to that effect, and SMECO, you know, they did respond that they felt this money may be needed in the future if this, you know, problem persisted. But again, we didn't do a extremely in-depth analysis of their financials to see if, you know.
I appreciate that because you can't in that amount of time. I do appreciate that. But did you take a look at like the increasing rate of arrearages? You know, some quick snapshot. What's happening out there? What's going on? Because people not paying their bills. What's happening? That's what we really need.
Right. Again, I think the timing for that is a problem. Again, we kind of shut down in mid-March. You know, the layoffs didn't really start happening till late March, early April. So again, to see if folks weren't paying their bills, I think we need a few months of data for that. So again, it was kind of hard within the short time frame from, you know, when they actually applied for this loan, when the shutdown really began, to see the effects.
Also, Commissioner, I think to a certain extent we viewed the broader policy implications of SMECO accepting this loan as being sort of beyond our purview. I mean, ultimately the judgment, and Congress put the judgment for this in the hands of the Small Business Administration and the banks that they chose to administer the program. And we did not view it as as us being in a position to second guess their judgment on whether or not SMECO was eligible.
Well, I appreciate that. In fact, it's a great segue, Mr. Spivak, because I was coming to you with exactly that next. So let's go there.
Okay.
So we're being asked to grant a waiver, right? Comar. That's essentially it.
That's correct.
But we're not limited in our examination of granting such a waiver. We have broad authority to determine whether or not such a waiver is in the public interest, right? So that opens up our purview broad and wide, right? Is that not true?
It opens it up within the commission's, within what's normally the commission's sphere of view.
Public
That
interest
is
very broad. It's the public interest.
it is quite broad, but you know, again, it's really kind of the legislative level where the judgment is made on who's eligible or not, or who should be eligible or not. You have pointed out that there's some feeling on the subject of larger companies getting a loan that was meant for smaller companies.
Hang on, Mr. Spivak. Let me stop you before you start putting words in my mouth, because I just want to answer my question.
I don't know. I don't think. Yes, I think the commission has broad authority with respect to its COMA waivers and whether it's in the public interest or not. But I don't think it extends to a legislative judgment that's already been made by the Congress of the United States.
Well, the legislative judgment in Maryland is that the legislature in Maryland has vested the commission with broad authority to exercise its discretion in the public interest on a broad range of things. And that should always be baked into our decision-making theory. It should be in the public interest, not just in the interest of the utility, because I could make a case very strongly that this is certainly in the interest of the utility, but I have to consider the public interest, which considers other stakeholders and other people in our community. In other words, let me give you an example. If small businesses in the SMECO service territory didn't get these loan applications because they didn't have the infrastructure and the personnel and the savvy and the moxie and the connections, they may go out of business and they may not be paying their bills and or arrearages to SMECO. So now I got an impact on my utility, and I got a public interest impact where the economy is impacted. And you expand that writ large across the service territory, I may have a big problem. That's a public interest item that should inform my decision. Wouldn't you agree?
Commissioner, as a staff attorney, I've always taken a certain amount of pride in being able to say that our job is in part to represent the broad public interest. I'm remain pleased to be able to say that. But that said, I mean, that's a level of policy judgment that we would not generally engage in as staff.
So if you take a purely myopic legal view of this issue, you'll say it's outside of our purview. But if you look at the broader public interest, I maintain you may take into other things into consideration that maybe a purely black letter of the law legal view may not look at. So I'm suggesting that we do have authority to look broader than the myopic view, maybe, of just looking at the black letter of the law and whether or not we can use fancy Latin terms like, well, I won't go there, but I can look at the economic impact that this decision and this waiver may make, can I not? I think it's being suggested that I shouldn't, that the commission shouldn't.
Commissioner, yes, if you choose to look at that is your prerogative.
All right, very good, thank you. Let me ask the company, Mr. McDougall, if you can answer some questions. Mr. McDougall?
Oh, I'm sorry. Your question was whether...
I didn't ask you.
Go ahead, please repeat your question for me.
Yeah, I didn't ask it yet. I was just trying to get your attention. So
I'm here.
How many employees does SMECO have currently?
I think we're in the neighborhood of 475.
It's pretty big operation, not big, but I know you meet the technical definition, but did SMECO worry at all in having its discussions that there's only a certain amount of capacity out there, federal help, that the federal government could shove out the door and help our true small businesses? Did SMECO worry about the mom and pops across the 4-county service territory that that may go out of business that you're no longer going to have as customers going forward in the unless the stimulus Paycheck protection program is used and accomplishes what it was for, that you may have extended problems going forward because business is not being saved and going out of business, and people being out of jobs. And while bigger companies who have capacity to endure, scoop up capacity. Mr. Speedback, would you mind muting? Not muting. Thank you.
So Don, was there a question at the end of your statement? I lost it because of the static.
Yeah, there was some background noise there that kind of stepped on me a little bit. So did you talk about and consider within SMECO the long-term effects that you're gobbling up that capacity in this PPP that wouldn't make it available to other small businesses and employees in the service territory?
Well, I'll say first, SMECO is very concerned about the financial health of not only its residential customers, but also its commercial and industrial customers. We are here to serve them, and they are our members, they are our owners. So we have great concern for their financial health and longevity. We're also concerned about the effect that the pandemic has upon them, and consequently how that might impact our operations. I frankly don't know how many of the mom and pops applied for PPP loans. I don't know how many were declined, and I frankly don't know whether any of that had anything to do with SMECO getting its PPP loan granted. What I do know is that we had a concern about how the pandemic would affect our cash flows moving forward, depending on the length of the pandemic, how it affected our customers, and how it affected our cash flows. And so it was prudent for us to make the decision to seek out these funds. How they are allocated is really the decision of the lenders. And we have no control over that, nor did we have any control over how much, who applied or anything of that nature. We only had control over our application, and we felt it was prudent to pursue that. It doesn't diminish our concern for the others. We frankly would hope that all of those in need would be able to get funds that would help them continue in their businesses.
I appreciate that. Would it be fair, though, to say that you have an office of general counsel, you have a legal department, you have a lot of staff and resources, and you were challenged getting in under the wire? I take it for your submittal. The true mom and pops didn't have a chance at this. Most of them, I think. So I think the $350 billion went so quickly that the Congress was shocked. The world was shocked. The Treasury Secretary was shocked that it went that quickly. And I'm trying to figure out, all right, what was the purpose of this? What's in the public interest, truly in the public interest? So let me direct your attention, if I could, to a data response that you provided to staff. It's data response item 1-12.
Give me a moment, Commissioner O'Donnell, I'll take a look at that.
Okay.
I have that.
So the question was, what effect does this debt issuance have on SMECO's capital structure? And the response was the PPP grant would have no effect to debt since it would be paid off within 1 year. It would increase equity because it should decrease payroll expenses and therefore increase margins, which would go to equity. What margins are you referring to?
Margins for cooperative are akin to retained earnings for a stockholder company. Or I guess I should say net earnings, which end up going to equity. So and that's what we're talking about. It would, to the extent that it reduced expenses, it would increase net income, which then would go to equity at the end of the year.
And what was SMECO's equity in its submitted 2019 annual report? Do you know?
I do not. I could.
If I told you subject to check that it was $29 million, would you think that's probably in the ballpark?
Well, I've got our financial people in the meeting here. I could ask them.
Fair enough.
Sonia Cox or Beth Kennedy there?
Hi, this is Beth Kennedy. That $29 million was after margins, not equity, and those margins are allocated to our members each year.
But that was my question. Those are operating margins, about $29 million, right?
Correct.
That was my question. How much the margins were? Thank you. So to get back to the data requests, Mr. McDougall, it seems to me like these funds are simply going to go to equity and to increase margins. And that's what it seems like that answer is saying to me. Please tell me why I'm looking at that wrong.
Ms. Kennedy?
This is Sonia Cox, for President and CEO of SMECO. And if I could respond to that. They are, there's a possibility. The question that was asked was, what effect will this debt issuance have on SMECO's capital structure? So we were answering that question. There's also the possibility that other costs would increase, or there's other factors that could come into play where they may not decrease expenses after all, and it would not increase margins. There's just so many unanswered or unknowns with this whole situation. It was really hard to answer that, to answer your question. But the specific question that was asked here was about the capital structure with this debt issuance, and that's how we responded. And that's with the best information that we had at the time.
Yeah, well, I appreciate that. My concern is that this displaced capacity for other people who are hanging on and in a much worse condition than SMECO is. I just want to be assured that SMECO is in not some extremis financial situation. Because if you are, part of my job is to make sure you're not in an extremis financial situation. And is this application and this waiver of COMAR an indication that you are? Or, on the other hand, are you simply trying to pad your margins in case this gets worse than we all think? In which case, everybody else is going to get wiped out anyway.
Well, we're not. If I could respond, this is Sonia Cox again. We're not in any way trying to pad our margins. Just since the beginning of March, our cash receipts are down $16 million. Our delinquencies are up by 10%. And as Mr. McAuliffe spoke earlier, Commissioner, these things, when we applied for this loan, this was just getting started. And from everything, because we're sort of in we are a lag industry or a lag biller, we really won't have a good idea of what this is going to do to our cash receipts in general or our margins in general, probably for several months.
I appreciate that. And in fact, I was asking Mr. McAuliffe and staff, if you listened to the previous question, about some indication of the health, and you just gave me more than this whole filing gives me. Would you mind repeating those numbers about your cash receipts and your what you ran through there pretty quickly, what impact you've seen here in the short term?
Yes, we are following this pretty closely, and our cash receipts since the beginning of March are down $16 million, and our delinquencies are up 10%.
And what would it normally? You're down 16 million. Out of what would it normally be? What would that normal amount be?
It's down 16 million over last year. I don't have the total with me. I would have to get that information and get it back to you, Commissioner O'Donnell.
I appreciate that, Ms. Cox. I'm trying to ascertain the health of the utility. Is this thing adversely affecting our utilities? Should other utilities be seeking out federal help? What is the real status of? And it's opaque to me. Trying to pull that, tease that out here. What is this application? What is this waiver? What is the health of the utility? Because I feel like that's my job, and that's really what I'm trying to figure out. So if you have additional information that you'd like to provide on this, my hope is we'll be able to consider this for a day or so, but I don't know what the rest of the commission is going to want to do. I'd like to do that because I don't feel like I have enough information on this and what it's really all about. So if you have financial data that you could provide that may help us, Mr. Chairman, I just, with all due respect, think that would be very helpful because I don't think we've gotten it here.
Thank you. Commissioner, do you have any additional questions?
I'm good. Thank you.
We'll move to Commissioner Richard.
Thank you, Mr. Chairman. Let's see, we've covered a lot of ground already, so I want to be careful not to repeat any of the questions. A lot of good information is already out there, but I just want to go back to the actual program itself. And Mr. McDougall, so this program was created, by Congress, and I'm saying very deliberately program because it was called the Paycheck Protection Program, and the idea was to get money out into the economy, particularly to business. And there was a definition of small business, which SMECO fell under. And the idea was to get this money out. And in fact, it was meant to be a grant because if people responded, if companies responded the way they were supposed to, this was not a loan at all. So did you approach that in that manner that, hey, we fall under this the definition of a small business, and these funds are there for us to help us with our payroll? Is that the way you approach this? I mean, was it just purely as a loan?
I believe we viewed it initially as a grant because of forgiveness provision.
Right. So, obviously there's a huge amount of uncertainty and economic. I think you kind of went over that, and you had a short period of time that you had to respond. And you are a fiduciary for your members. And as you stated here, there were a lot of uncertainties about the current economic conditions. And in fact, it sounds like not only prudence, you were prescient in being able to get some of these funds because of the impact, the financial impact on your company. Is that kind of how you approached it then, and how it seems to be playing out?
That's precisely how it happened and how it seemed to be playing out at this time, Commissioner.
Okay. And you were not an outlier. It sounds like you all immediately thought, gee, we better also check with our other co-ops. So I thought that was an important piece of information for me too, that you reached out to co-ops, and again, you only had this short period of time to take an action on behalf of your members, and so you were trying to be very careful in how you approach this program. Is that correct? Is that some of the thinking by the company?
There was no knee-jerk reaction on the part of the company. We did think about it. We made sure that we met the definition of a small business under the PPP. We looked at what certainty or uncertainty we had moving forward with the pandemic, and really there was zero certainty. And everything was uncertain, and at that point in time, we felt that it was prudent to make sure that we were able to maintain our level of service moving forward into the ensuing months.
Great, and that seemed to be, it turns out, the thinking of a lot of the co-ops wanting to look out for their members and wanting to avail themselves of this government program. Did I hear that correctly in this conversation, that you're not alone? Other co-ops, and maybe that wasn't your testimony, but I think Mr. McAuliffe in his research found that.
Well, I think that Mr. McAuliffe in his research, and I, having seen, like I said, email traffic from the Electric Cooperative Bar Association, just knowing that there are other co-ops who have made that same determination and have to apply for loans.
Right. And you said this is an extraordinary type of program. I mean,
I've never seen anything like it.
Right. When you approach loans in the past, or applications for financing, I mean, was it a similar process that you have gone through as you went through in this program? And did they ask you how big your company was? Did the funds, did they originate from the federal government specifically to get out the door with a provision that you could actually be forgiven if you use the funds the way the institution wanted you to use them? Is that normal or is that extraordinary?
These are extraordinary times, and they come up with extraordinary situations, this being one, Commissioner Richard. I've never seen a federal loan provision that allowed for forgiveness if used in a particular way. The loans that we've had in the past, at least for the years that I've been here, didn't have any such provision in them.
Mm-hmm. And then if you didn't use the funds the way the institution wanted, I mean, have you ever seen something with a low, such a low interest rate, something you've never seen before, that they said, well, okay, well, in those circumstances, you're going to have to pay it back if you don't use it the way we want to. Is that a normal financing instrument that you've ever dealt with before?
I've not seen it.
Right. So now I was impressed too that, it seems from your filings that you did take one extra step here. If things changed, if the federal government, redefined or had some other kind of, clarification, that you would in fact repay this loan. And it sounds like you were thinking ahead, that you didn't want this to be a long-term loan. You wanted to make sure you fell under the long-term loan requirements. And so before we started talking about this, your president signed an affidavit that you would pay this back, which is, again, it's sort of extraordinary, even the way you deal with the Public Service Commission. Is that correct?
That is correct. I again have never seen a loan from a lending institution at as low as 1%. Normal businesses in the normal situations would, with a 1% loan, take the full term to repay it because it's such cheap money. But given the situation here and needs for money, we thought that we would, pay it back more quickly if indeed it was not forgiven, which we believe is going to happen.
Yeah, in a sense, that was kind of working. Maybe I don't put it this way, but not necessarily as a fiduciary in the best interest of your members, but instead you wanted to make sure you were falling under the spirit of this program, and that's the way I interpret what you're saying.
Thank you, thank you, Mr. Commissioner. That is indeed true.
Okay, well, thanks. Can I just ask a question then of Mr. McAuliffe? Is he still there?
Yep. Go ahead.
Yeah. You mentioned that it's not necessary that we just act right today, or the law doesn't require today. This whole nunc-pro-tunc. I mean, can't we look into the future if for some reason this becomes clearly a long-term loan? Can't we just put that off into the future and then nunc-pro-tunc this to a long-term loan? I mean, is there any reason we need to put the company through hoops today under these circumstances? I get it. Maybe it's not burdensome, as even the company admits, but it just seems so unnecessary and so tone deaf to what's going on right now. Can we put this off?
Well, I'm not sure that we can. I mean, the COMAR is pretty clear that this is all needed up front. Again, I would kind of.
But that was nunc-pro-tunc. We could do anything retroactively.
The nunc-pro-tunc is authorization to issue the loan itself for SMECO to incur the debt. That's not necessarily.
We don't know if it's a loan right now. I mean, it's likely to be a grant. And I mean, if we believe why would we disbelieve the president of the company that signed an affidavit that they will pay it back and it won't be a long-term loan, which I think is so unlikely because they intend to use it for payroll, which means it will be a grant.
If I might try and respond on that. Yes, the company has made that assertion, but I mean, yes, the commission can act nunc-pro-tunc, but in doing so, it's probably not the best idea to extend the retroactive period any longer than it absolutely has to be, and kind of take a wait and see. If you do that, what you're essentially doing is granting the company's original request or basic request, which is to rule that this is not a long-term loan. And staff was unwilling to do that because we looked at the plain terms of the document that they've signed, and it said it's a 2-year loan. Now, we grant that the company has said that it will pay it off in a year. I think we're safe in assuming that they will make their best efforts to pay it off in a year if it's not forgiven. But we also know that things can happen. So we don't know where it will ultimately end up. What we do know at this point is that the loan they have actually signed says that this is a 2-year loan. And we thought that was a pretty bright line, and we thought it was advisable to adhere to that.
Okay, well, yeah, thank you for that. I guess my view from everything I've heard that this may not be a loan and likely not to be a loan. And I think the terms that we're looking at are so extraordinary. I think to try to put this in this box, I think is premature, and I would even say misguided at this point. Well, I guess that. I mean, personally, I applaud the company for availing itself of this paycheck protection plan, looking out, likely looking out for its customers, and it appears that's what's happening. And it just really bothers me right now if we would do anything that would put them through additional hoops in these circumstances. So anyway, thank you, Mr. Chairman, for the time.
Thank you, Commissioner Richard. Obviously, with a 5-member panel, you have a range of viewpoints, and I think we've seen that today. Obviously, the PPP, from a public perspective point of view, has been a controversial program. If I were to have created it in retrospect, it would have different rules, different controls. But it is what it is. We have no oversight of that program, and what we do is have an application for the issuance of long-term before us. I do view it as a 2-year note, although I recognize the utility's intent is to view it as a grant with no intent to repay, because those funds will be applied for payroll purposes. And I don't begrudge the utility for doing that. However, based on what I've heard today, and I have no questions, I think all the questions have been asked, I'm going to pull this item, take it under advisement, as I heard echoed from some of the commissioners, for the commissioners to deliberate further and issue a written order in the very near future. Yes, Mr. McDougall, that discussion on 2 affidavits seemed like a lifetime ago. Any further statements or comments before we move to the next item? Okay, so we're taking item number 9, the SMECO request for approval of short-term debt under advisement. Mr. Secretary.
Thank you, Commissioner.
Thank you.
Mr. Chairman, item number 10 consists of revisions from Baltimore Gas and Electric Company to its electricity supplier coordination tariff for transfer of price responsive demand credits. And on this item from staff, we have Kevin Mosier and Annette Garoppolo, and from the company, David Bloom and Beverly Sikora.
Thank you. Good morning, technical staff.
Kevin Mosier on behalf of staff. On December 4th, 2019, the commission approved changes to the BG&E, Delmarva, and Pepco tariffs that enables the companies to receive all price responsive demand credits owed to them by PJM. The companies sought these credits on a zonal specific basis. However, PJM requires that these credits be allocated on an RTO-wide basis. To address this issue, on April 17th, the companies proposed edits to their tariffs that will establish a PJM holding count in Pepco's name. PJM will then deposit all the credits from across all 3 utility zones into the holding account, and Pepco will distribute the appropriate shares of the credits to BG&E and Delmarva. Staff believes the company's filings are reasonable, and therefore staff recommends the commission accept for filing the company's proposed revisions to their electric supplier coordination tariffs.
Thank you, Mr. Mosier. Good morning, counsel for BGE.
Good morning, commissioners. Beverly Sikora on behalf of Baltimore Gas and Electric. I have no additional comments, but we're here for questions if you have any.
Thank you. Do commissioners have any questions? I see none. I'll propose that we accept the tariff revisions for filing with an effective date of June 1st, 2020. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
Commissioner Herman.
Aye.
I also vote aye. Sorry, Mr. Carr, for the long wait today. The motion is approved.
Mr. Chairman, item number 11 consists of revisions from Potomac Electric Power Company and Delmarva Power and Light Company to their electricity supplier coordination tariffs for transfer of price responsive demand credits. On this item, for staff, we have Kevin Mosier and Annette Garofalo, and for the companies, Matt Seegers and Cynthia Nowell.
Thank you. Mr. Mosier.
Commissioners, Kevin Mosier on behalf of staff. This is identical to the previous issue, just for PHI versus BG&E.
Thank you. Any response from counsel for the utilities?
Good morning, Mr. Chairman and Commissioners. Matthew Seegers appearing for Pepco and Delmarva Power. I have nothing to add to staff's comments. Just here if you have any questions.
Thank you, Mr. Seegers. I do not see any questions from the committee.
Mr. Chairman, I actually have a question.
Oh, Commissioner Herman.
Thank you. Mr. Seegers, will Pepco be keeping track of the time and allocate costs, if there are any costs, to the various companies pursuant to cost allocation manuals?
Your Honor, it's my understanding that there will be no incremental costs associated with this. So I'm not sure if that answers your question.
Okay, yeah, that does it. I just wanted to, since it's going across multiple companies, if there were costs, whether they were going to be allocated.
Yes, any costs will be allocated according to our cost allocation manuals.
Thank you.
Thank you, Commissioner Herman. At this point, I will propose that we accept the tariff revisions for filing with an effective date of June 1st, 2020. Vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell. Sorry, Commissioner O'Donnell, did you, I think we lost you for a second. Your vote?
I'm sorry, Mr. Chairman, I'll go to aye.
Thank you. Commissioner Linton.
Aye.
And Commissioner Herman.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 12 is a request from Cypress Creek Renewables LLC for an extension of operational deadline to construct its community solar energy generating system. For staff, we have for the company, we have Christopher Mudd and Dewey Chlorfield.
Thank you. Good morning, staff. Oh, Ms. Garofalo, your mic is off. There we go.
Okay. Cypress Creek Renewables is requesting a waiver of the operational deadline established under COMAR 20-620304C. The waiver is requested to cover the period May 13, 2020 to January 30, 2021. Cypress Creek had been subject to a pending legal challenge, which was eventually resolved in May 2019, following which applicant asked for and was granted a time-limited waiver through May 15, 2020. As good cause, which is required under COMAR 20-620104 for the granting of the current waiver, applicant notes the unprecedented nature of the current pandemic, which has resulted in delays in local permitting of uncertain magnitude. According to Cypress Creek, delays in construction may also recur as a result of the permitting delays. Staff recommends that the Commission find good cause for waiving the construction deadlines established by COMAR 20-620304. The pandemic and its mandated response were not foreseen at the time applicant began planning for the construction of its solar facility. Staff itself has filed a general request for deferral of deadlines until a revised COMAR 20-620304C becomes final. And for its part, the Commission has noted the executive order issued by Governor Hogan on March 12, 2020, and issued a general order suspending Cypress Creek's and other community solar deadlines until 30 days after the end of the current state of emergency or the date the revised regulations become final, whichever is earlier. However, both of these dates are currently unknown, and since Cypress Creek's deadline is in 10 days, Staff recommends that the commission grant Cypress Creek a time-limited waiver to January 31, 2021.
Thank you. Good morning, Council for Cypress Creek Renewables LLC.
Morning, Mr. Chairman, members of the commission. Can everybody hear me this morning?
Yes.
Thank you. My name is Christopher Mudd. I'm an attorney with Pinnacle.
Oh, we're losing you now, I think.
Sorry. Hear me?
Now we can, yeah. We hear nothing at this point.
Can you hear me now?
Now we can hear you clearly now.
Okay. Thank you. Sorry, my microphone's a little fickle.
No, we lost
renewables.
Okay. Obviously, there's a sensitivity problem there. Could you possibly take out the mic? Do you have another microphone built into your laptop?
How about now?
That sounds good for the time being.
Okay. I'll keep it short. We certainly support the staff's recommendation. Mr. Clearfield is on with us as well in case there are any.
Okay, we lost you. We might have your colleague do some of the speaking if he's able to. All right. The second request of Cypress Creek that at least I've seen, and I'd like not to see a third one. I'm supportive of granting a second request, but at the same time, I see that you're pushing your request right up to the wall where BGE says that the earliest they could interconnect is January 30th or 31st. So I'm asking, is that enough, or do you need to be back for a third waiver request? Or are you pretty confident that this will happen before January 30th?
Cypress Creek's every intent is to move as fast as possible.
Please state your name and affiliation.
Sure. My name is Dewey Clearfield. I'm the developer for these projects. I've been with Cypress Creek for about 3 years, and I've been working on these projects for about 1.5 years.
Okay.
So Cypress Creek's every intent is to build the project as soon as possible, as both staff and council indicated in the filing and their words. County permitting has taken longer than expected. We started that in earnest. We bid it out and gave notice to proceed for that permitting work in July of 2019. And we've been diligently going back and forth with the county on various permitting aspects. In order to meet the
Mr. Clearfield,
utilities.
I'm not worried about that. I read that, I see that, I understand it, and I've seen that before with these projects. I'm just asking with respect to BGE saying that they won't be able to tie in before January 31st, and you're only asking for an extension to that same date. Are you confident that you'll have this done before then?
I am presuming that we get those development permits in hand in the short matter of speaking, which I expect. I would anticipate that we'd be able to give a notice to proceed as soon as possible for construction, and the circularity of it is that we have to provide a certified shop drawing for the switchgear equipment on site in order for the utility to be able to begin its own procurement, and we cannot do that while the discretionary permitting is outstanding. So as soon as that drawing is as soon as the permits are approved, we'll be able to provide that shop drawing, which we have to put a deposit down in our EPC. And we would anticipate being able to move on our end for that 1/31 deadline. Obviously, these are unprecedented times, and we are unable to, we don't have a lot of insight into the utilities timeframe and their procurement delays, but on our side, it's our intent to meet that deadline.
Okay, I'll take your word for it. Cutting it close, but I'll take your word. Do commissioners have questions? Sorry, I have to flip between screens. I do not see any questions from the commissioners. At this point, I will make a motion that we grant Cypress Creek Renewables LLC a time-limited waiver of COMAR Title 20, Subtitle 62, Chapter 3, Regulation 4C through January 31st, 2021. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Connell.
Aye.
Commissioner Linton, and Commissioner Herman.
Aye.
Thank you. The motion, I vote aye. The motion is approved.
Mr. Chairman, item number 13, River North Transit LLC's petition for a waiver of fingerprint-based background checks. For staff today, we have Kenneth Albert and Regina G. For the company, Caitlin Brady, Jonathan Cohen, Ryan Sullivan, and Brian Quinn.
Thank you. Good morning, staff.
Good morning, Chairman, Commissioners. Kenneth Albert on behalf of staff, along with Regina Gee. This item addresses a request by a transportation network company, River North Transit, for a waiver under Public Utilities Article 10-404E of the requirement to conduct a fingerprint-based background check of people who apply to serve as a driver, referred to as a transportation network operator, or TNO, for River North. River North asserts that its alternative background check process for its drivers is at least as comprehensive and accurate as the fingerprint-based background check required by the Public Utilities article. River North is relying on a company named Checker to provide these background and driver record checks with respect to the applicants to drive for River North. Checker, you should know, is the same background check provider that was used by another TNC, Razier, at the time that the commission granted Razier a waiver of the fingerprint requirement in order 87957 in case number 9425. The waiver allowed Razier to use Checker to conduct name-based background checks of the driver applicants. In that same proceeding, 9425, the commission also granted a waiver of the fingerprint requirement to another TNC, Lyft. Checker and its associated employees are accredited members of the National Association of Professional Background Screeners. And to achieve this accreditation, they passed a auditing system as well as a review of their systems and procedures. Staff has verified that Checker will provide background screening services for River North, utilizing at a minimum the same structure and guidelines that are used for background checks conducted for Razier. In case 9425, Razier and Checker presented comprehensive testimony that described in detail the background checks and the methods used by Checker. In granting the fingerprint waiver to Razier, the commission required Razier to adhere to strict guidelines in addition to performing self-initiated regular inquiries into the criminal backgrounds of their drivers. The commission also required Razier to comply with several additional requirements that are discussed on page 6 of the staff's comments. River North's responses to staff's data request that went into great detail on exactly how this background check will take place are attached to the confidential version of staff's comments. By imposing the appropriate conditions, a waiver of the fingerprint requirement to allow River North to utilize Checker to conduct background checks would satisfy the requirements imposed by the commission in granting the fingerprint waiver to Razier. Therefore, staff recommends that the commission, 1, grant River North a waiver of the fingerprint-based background checks required under the Public Utilities article. 2, approve an alternative background check for River North to be used in lieu of the fingerprint check. 3, require River North to adhere to all the conditions adopted by the commission in case 9425 in connection with the fingerprint waiver that the commission granted to Razier and Lyft. And 4, require River North to notify the commission within 10 days regarding whether the commission accepts these conditions.
Thank you, Mr. Albert. Very nice summary. Good morning, Council for River North Transit LLC.
Good morning, Mr. Chairman. It's Brian Quinn with Venable here on behalf of River North. They're going to be operating as VIA in the state of Maryland. We agree with staff's conclusions, and there's comments that River North fingerprint waiver application is as comprehensive and accurate as the CGIS requirement, and we agree with their recommendation for approval of our application. I have members of the company here to answer any questions you have, Mr. Chairman.
Thank you, Mr. Quinn. Looking to see if the commissioners have questions. I do not see any.
I have a question, Mr. Chairman.
Commissioner O'Donnell.
Thank you, Mr. Chairman. I guess I'll ask this of staff. In our order 87-957 in 2016, I thought, if memory serves me correctly from being there then, we issued an order that had a nuance of differences in the processes approved for lift and raise air. Maybe something to do with how they contact their prospective TNO. One did it with an already approved associate, I think, and another one sent in a picture, did something else. There was some nuance of difference between the two companies in their background check process and their onboarding process. Well, first of all, let me ask, is that so? Can you tell me if that's true, that there were a little bit of differences between the two approvals?
Good morning, Commissioners. This is Regina Gee with Transportation Staff. You are correct. There were some minor differences between the way the two companies processed their backgrounds and their applications and met with their applicants. River North is fits a little bit more closer to Lyft's model. They do perform face-to-face interviews with their applicants.
Okay, so that sets up, I appreciate that, thank you. So this proposal here from staff says, require the company to adhere to all conditions adopted by the commission in order number 87957 in connection with fingerprint waiver that the commission granted to raise ear and lift. Okay, so, but if they're different, do they have to comply to both? They have to do both processes? How does that work?
No, just the additional sections that the commission requested, as far as like the affidavits that needed to be submitted with the applications, the verification of the identity of the applicant, the responses to the activations, the self-reporting requirements. As far as the processes for each company, they would still have to maintain what they answered in their data request to us as to what their current process is. They would still have to follow that same process. So that's why we did include in our comments that including our exhibits, which would be all their data requests and the confidential filing.
Okay, so they would be committed to in-person interviews with the prospective TNOs, and then and we would hold them to that because that's the way they submitted it, notwithstanding what the proposed recommendation.
Right, that is correct. And just a little bit more background, we actually started our dealings with River North back in February of 2019. So we've been dealing with them for about 15 months now. So even though this current filing just took place in December, they filed originally in April of 2019, and then they withdrew that filing in late October of 2019. So, but we've been dealing with them for the past 15 months, and we're very satisfied with what their process will be.
Okay, Ms. Gee, thank you. I appreciate that very much. Mr. Chairman, I'm good. Thank you.
Welcome.
Thank you, Commissioner. Any additional questions? At this point, I'll make a motion that we grant the company a waiver of the Fingerprint-Based background check required by Public Utilities Article 10-104B, that we approve an alternative background check process for the company as specified in staff's comments and the accompanying exhibits dated April 7, 2020, to be used in lieu of the Public Utility Article Section 10-104B fingerprint-based background check. That we require the company to adhere to all conditions adopted by the Commission in Order 87-957 in connection with the fingerprint waiver that granted to Razier LLC and Lyft Incorporated. And finally, to require the company to notify the Commission within 10 business days regarding whether the company accepts the requirements imposed by the Commission in connection with the requested waiver. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell.
Aye.
Commissioner Herman.
Aye.
And Commissioner Linton, I tricked you there.
You almost got me. Aye.
I also vote aye. The motion is approved. With no other business before the Commission today, this meeting is adjourned. Thank you.
Thank you.